So we're now going to jump back into Stephen Bradshaw's testimony to the Post Office Horizon IT inquiry and get into the nitty-gritty of who was responsible for disclosure. Now, the legal advice passed on says you'll be aware of your responsibilities to with disclosure about anything pertaining to the case which could undermine our prosecution. But Stephen Bradshaw still seems to firmly say, well, if I've disclosed it before, the lawyers should be searching for it. Who's right? Let's jump into the inquiry.
Can we please look at poll 000565996, please? This is at an earlier stage in the case. This is a memo from Maureen Moores in the National Security Team at the Post Office.
That's a new one. I don't think we've heard that before. The National Security Team sounds important.
It's about this particular case, Mr. Ishak, and it's sent to you.
That's right, yeah. Maureen Moores was part of the casework team. She was a postal officer in the casework team.
So she was a caseworker, you were the investigator.
Yeah.
And she gives an opinion as to sufficiency of evidence, or
not at all. All she's basically done is forwarded on that's been addressed from legal services, because this is round about the time of the crossover between the criminal law team, i.e. John L. Singh, and Cartwright King taking over completely.
Yeah.
So the legal services, that's where they were based as Royal Mail Group. When the split come, lawyers stayed with Royal Mail letters. John L. Singh become post office, and they would then send it to the casework team, and in this case, Maureen, and Maureen would forward that on so it would be attached into the file.
So, for whose attention was this particular document?
I think it's to let the security team know, and it's forwarded on to me, and I would put in.
So, as the investigating officer, is this? If we scroll up, sorry, it's a memo, so it's not a letter.
No.
Is this effectively a memo for your attention?
Yeah.
Yes. Could we scroll over the page, please? And we can see at the very bottom, it's from Rob Wilson, who is at that stage head of the criminal law team.
That's correct.
Now, when we go back to, back to John L. Singh's testimony, I'm sure he said Rob Wilson didn't want the job of head of criminal law and it kind of fell into his lap. But clearly at some stage he was head of criminal law. Maybe this was prior to the time that he was talking about, I think, if we're looking at 2010.
If we look at the very top of the current page we're on, he says as follows: you will be aware of the provisions of the Criminal Procedure and Investigation Act 1996 concerning disclosure. Please confirm whether there is any material which might reasonably be considered capable of undermining the prosecution case or assisting the defence case and which has not already been disclosed.
And it's important to know at that point they aren't saying that's just related to this case, they're saying any evidence that's available, i.e. including other cases as well, even if you think the solicitors or the criminal law team are going to include that by default.
Please also let me have various forms. So that is a test that you were aware of?
That's right. They're all the forms for the committal,
Yes. So that is a test that is being repeated to you by the head of the criminal law team.
That's right.
Do you still say that it was the responsibility of Cartwright King to ensure appropriate disclosure and not your responsibility?
Cartwright King if you're talking about the misery part, for Cartwright King, now I will have disclosed everything that I had pertaining to that case. Anything above and beyond it, I would expect the lawyers to disclose it to the defence.
There's no caveat in that paragraph, though, is there? There's nothing that says in that paragraph, in the particular circumstances of this particular case.
No, and I wouldn't expect it to be any sort of thing. It's any caveat to be put in for there. As I said, all internal work that I had, I would disclose to our lawyers.
All internal work that related to this particular case?
Yeah.
And where did you get the impression from that that's all you needed to do?
That's the way I've been told from the business from when I started.
So the problem with that then, if he's been told that's the way to operate by the business and that is indeed true, then it would cast, if there's been when there's been previous cases, whether any of the cases have had sufficient disclosure because they've not considered necessarily by the sounds of it, by direction, the disclosure of materials from other cases that have been prosecuted.
Oh, by who?
The way it's come down from when I started, and from the training school to whoever the sort of, like Mr. Gardner at the beginning, when you first done them. And the lawyers haven't said we've done anything incorrect.
So was it part of your training that you only need to disclose matters relating to a particular case and not be concerned with wider issues?
As far as I recollect, yes, that's what it was.
Do you have any reflections on the fishing expedition comment? Do you still see it as a fishing expedition in this particular case?
As I said, people sometimes send emails as if they're having a telephone conversation, and it's probably not the correct way to use fishing. But at the time, it's probably a prevalent way people will speak to one another.
But do you think that wider disclosure about problems with the Horizon system experienced by other sub-postmasters is not a reasonable thing to need to disclose?
If there was issues there and the lawyers knew about it, they should disclose it.
You knew.
So he's firmly putting this back on the lawyers there, saying it wasn't our responsibility as investigators and that was the way I was trained.
The lawyers, as I said, I expect the lawyers to do that, not me. I've disclosed all relevant work I had pertaining to whatever case, and the lawyers would deal with the defence lawyers.
Maybe a lawyer will be able to help us with this in the comments, but is this the way, I don't know, any commercial lawyers, if they can leave us a comment, is this the way a commercial lawyer would approach a case, as in they'd search all their own records, even if they've got somebody signing off something as a disclosure to see if there's anything from any other cases brought by a specific client, an organisation in this case, to see if there's anything relevant to this case, or would they just take what is filled out in the disclosure form and only submit that?